Ready? Start. Section 71 of the Evidence Act is in the nature of a safeguard to the mandatory provision of Section 68 of the Evidence Act to meet a situation where it is not possible to prove the execution of the will by calling attending the witness. Full stop. This section provides that if an attending witness denies or does not recollect the executions of the will, the execution may be proved by other evidence. Full stop. Aid of Section 71 can be taken only when the attesting witnesses, who have been called, deny or fail to recollect the execution of the document to prove it by other evidence. Full stop. Section 71 has no application to a case where one attesting witness, who alone had been summoned, has failed to prove the execution of the will, and other attesting witnesses, though are available to prove the execution of the same for the reason best known, have not been summoned before the court. Full stop. It is clear from the language of Section 71 that if an attesting witness denies or does not recollect execution of the document, its execution may be proved by other evidence. Full stop. However, in a case where an attesting witness fails to prove the due execution of will as required under clause C of section 63 of the Successive Act, it cannot be said that the will is proved as per section 68 of the Evidence Act. Full stop. It cannot be said that if one attesting witness denies or does not recollect the execution of the document, the execution of will can be proved by other evidence dispensing with the evidence of the other attesting witnesses. Full stop. Para 8, another reason as to how other available attesting witnesses should be called when the one attesting witness fails to prove due execution of the will is to avoid the claim of drawing adverse interference under section 114 illustration of Evidence Act, placing the best possible evidence before the court of consideration is one of the cardinal principles of Indian Evidence Act. Section 71 is permissive and unbailing section permitting a party to lead other evidence in certain circumstances, but section 68 is not merely an unbailing section. Full stop. It lays down the necessary arguments and the which the court has to observe before the holding the document is proved. Full stop. Section 71 is meant to lend assistance and come to the rescue of a party who has done his best, but driven to a state of helplessness and impossibility cannot be let down without any other means of proving due the execution by other evidence as well. Full stop. At the same time, section 71 cannot be read so as to the observe of a party of his obligation under section 68 read with the section 63 of the Act and library allow him at his will or choice to make available or not a necessary witnesses otherwise available and amenable to the jurisdiction of the court concerned and confer a premium upon his omission or lapse to the enable him to give a go by to the mandate of law and to prove a execution of a will. Full stop.